on behalf of the defendant.
Mr. Martin. All right, Mr. Martin, can you tell me your first and last name?
But first, I object. I'm not the defendant here.
Then I'm going to issue a bench warrant for your arrest.
Whoa, straight out the gate, this one's tense. Did you catch that? A defendant objecting before even giving his name. Classic courtroom chaos, and we're just 12 seconds in. Buckle up.
You're here. I'll recognize you. You're Mr. Martin. Okay. I understand. Let me ask a few preliminary questions. I know, Mr. Gazicki, you need to make a record. Is the complaining witness present for today's bench trial? Okay. Okay, thank you.
Two issues. One on discovery. We were here about 2 weeks ago. I did receive discovery, I believe it was like June 23rd or so on. I've been on vacation since the 3rd of July until yesterday. I had no opportunity to go down to the jail to visit Mr. Martin. But with, today I handed him a redacted copy because according to the discovery procedures in Wayne County, the only files I can share with the defendant are redacted. As far as the video goes, I have no other means to, redact that, to show that, or to give him a copy. Today I handed Mr. Martin a redacted copy of the police report that I did have. Okay. With that aside, Your Honor, I do want to make a motion to withdraw. I have had contact with Mr. Martin in the past and ended up with the same position I am right now.
So here's the tea. When an attorney asks to withdraw, especially over communication breakdowns, it's a red flag. Not just for the lawyer, but for the case. Would you want a lawyer who can't even speak to you properly representing your freedom? Let me know in the comments.
There's no communication between the two of us. There's, different thoughts on how to proceed and so on that I cannot adhere to. So I'm asking the court to withdraw on this matter.
Mr. Martin, have you had a breakdown with your attorney?
No, he's not doing his job. So, like as he admitted, he hasn't brought me to discovery. So I just told him I'll file a motion to dismiss the case, then based on the ineffective assistance of counsel.
Okay, well, you can't dismiss a case on that. I'm asking you a specific question as it relates to Mr. Gazicki. Do you want him removed from your case?
As long as he's not going to do nothing that's going to jeopardize the case further, like try to delay, like he asked me, do you want to do adjournment? I said, no, I'm not going to adjourn on the trial. I'm going to just sit in jail while I'm waiting. So I don't consent to him doing nothing that's going to jeopardize or violate my rights. But as long as he's doing, what he's supposed to besides it, I have no problem with it. But
Quick legal insight. Just because you believe your attorney is ineffective doesn't mean the case gets tossed. Courts require a very high bar to prove ineffective assistance of counsel. Think actual negligence, not just disagreement.
You understand, Mr. Martin, I've told you this previously. It's against the court rules for them to file frivolous motions. So Mr. Gazicki cannot, as your attorney, make motions that are frivolous. And some of the motions that you've previously presented to this court are in fact frivolous. Okay, I have jurisdiction. So if you're asking Mr. Gazicki to file a motion on the basis of jurisdiction, he cannot do that. Do you understand what I'm telling you?
No, one, I didn't ask him to file a motion specific to no jurisdiction.
Well, you've asked him to file a motion to dismiss today.
No, I didn't ask him. I just told him I was going to do it myself. That I was going to file the motion to dismiss the case because of his ineffective counsel not providing. Okay, that's not a reason for a dismissal. Sure.
Okay, so Mr. Martin.
I'm going to move. Well, if it's right now, I'm going to move for that. That's why we're talking about it.
Okay, denied. What's your next one?
Based on what reasons?
Okay. So, do you want Mr. Gazicki to represent you or not? Yes or no?
I'm going to say no.
Okay. There's been a material breakdown of the attorney-client relationship based on both counsel and Mr. Martin's assertions. So, Mr. Gazicki is withdrawn from the case.
Thank you, Honor.
Yep, thank you. Now, Mr. Martin, you have to make some decisions. Do you want an attorney appointed to represent you on this? I know
unless one's immediately right now, no, because I'm not going to allow a delay in this case due to
Well,
These
Mr.
incompetent
Martin,
attorneys not doing their jobs constantly.
Mr. Martin, you have a constitutional right to an attorney. If you can't afford one, I will appoint one for you. Do you understand that?
I comprehend that, yeah.
Okay, so here's the thing. I don't.
Did he just say 24 years of prison law study counts as law school? This moment brings up a real question. Should experience behind bars count as legal education? Sound off. Does time served equal time study?
I don't want you to say that you don't want an attorney because you want to go to trial right now, unless you have a true understanding of what that means. Because you can't go back later and say, well, now I want to appeal because I wasn't given counsel because I said I didn't want counsel because I want to go to court right now. Do you understand that?
Oh,
I'm happy to adjourn this for a week
but
so that you can have an attorney.
why I sit in jail? No, so I don't agree with that. So no, I can present myself. I've been doing law 30 years, studying, practicing.
Well, it's not been going very well for you, Mr. Martin. It might be time for you to get an attorney.
No, I don't agree with that. I've been beating several cases myself.
Okay.
So regardless of that, this is a simple case anyways.
All right, Mr. Martin, listen to me. You understand. I want you to understand a few things, okay? Again, you have a right to an attorney at public expense. We could expedite this case and put it on a docket right away. It's a bench trial. So I could get you on, next week or later this week. I'm not certain if that's possible. It would likely be next week so that you could have a lawyer and that lawyer could represent you. And I want you to think about that because Mr. Martin, if you have a constitutional right to a lawyer or to represent yourself if that's what you want to do. But I need you to take the passion out of it, take the heat out of it for a minute and think about what you want to do as a smart decision. Do you want to wait a week for a trial and have an attorney present or not?
No, I don't want to delay this because there's no guarantee the next attorney may do the same thing. Just keep on not doing their job and then think they're going to delay me. So no, I'm ready to go forward. And I have.
You understand, Mr. Martin, that if you chose to represent yourself at this hearing, you're held to the same standards as an attorney. And do you understand that?
No, objected under Haynes versus Kerner, U.S. Supreme Court case. Pro se litigants are held to less stringent standards than formal pleadings drafted by lawyers.
Okay, well, this isn't a formal pleading. These are questionings of witnesses.
The same
well,
thing.
No, it's not the same. I want you to listen. Mr. Martin, I'm trying to make sure your rights are protected right now. I'm asking you to get an attorney. You've indicated you want to proceed without one. And I'm asking that you understand I'm not going to allow you to get up here and ask questions in a way that are inappropriate to witnesses.
I want a jury of sovereign citizens, okay? Here's where it goes off the rails. The Constitution guarantees a jury of your peers, but not the kind you choose like a fantasy draft. This is legal reality, not Reddit court.
You can ask questions, you can get answers, you can ask more questions. But I'm not going to allow this to meander into something that it's not. Do you understand that?
Well, I do my best. If it, do something, that comes that you let me know or whatever. But of course, I know the basics of presenting a case, be it criminal or civil. So,
Did you go to college for 7 years to be a lawyer?
Not official college, but when I was in prison 24 years, I studied the law library for 24 years straight.
Okay.
30 years now counting.
And now we loop back. Mr. Martin doesn't trust any attorney, but also says he wants one for appeal if convicted. It's a legal tightrope act. Is he setting up a future I told you so, or just trying to keep his options open?
So
Okay.
there might be a
That's
few
your
things I might
choice.
forget.
If that's, Mr. Martin, I'm not, look, you and I have gone back and forth for several hearings at this point. I'm not going to change your mind on things. I know that, right?
Right, yeah.
You have a right to a trial. You have a right to a trial by jury or judge. You've previously waived your right to a trial by jury. Is that correct?
Right, yeah.
Okay. And so
Since
here
I'm
we,
not gonna get a jury by, like I really want, a jury of my peers to be those of the sovereign people, since that was denied before Slayton's court. Same.
yeah,
years.
do you know, where am I supposed to go to get a judge of, a jury of sovereign citizens? I mean, that's not how it works. That's not what the Constitution requires. So you're waiving your right to a trial by jury, correct?
Only because, like I said, I can't get a jury by my peers of sovereign people.
Oh, okay. And are you waiving your right to an attorney?
As of now, but let's say, worst case, let's say even though I shouldn't, there's no evidence, even if it was to be guilty, I would then want an attorney to represent me on appeal, I'll say that. But,
Okay, well, I want you to know that you would have a constitutional right to have that attorney too.
right.
And
But
if
as
you're
of now,
found-
no, because these attorneys keep, like I said, they keep doing this, it's
Okay.
constant.
Okay,
You know, that I've been having, not doing their job and holding me up, I'm not.
Okay. All right. Is there another, Officer Frisky, Officer Kemp, can you come up for a second? If you can stay with the prisoner.
But also I need,
Give me a second, okay?